তাই তো? কাইন্ডলি কাম টু গ্রাউন্ড। কোথায়? আরে ভাই ওরকম ভাবে হয় না, ইউ নো এভরিথিং, দেন ইউ আর
Give the copy.
very nice, I will know. Don't show to your temper, Mr. Sam.
Listen, it is the first matter in the morning.
But I am, why he is showing this?
No, he wants
Soft
to
copy.
know what you are relying
But I am
on.
saying, I was sending him to soft coffee.
Whatever, let him know at least.
Yes, I am sending him to soft coffee.
Yes,
Even then he is shouting.
yes.
But kindly come to first. Ground number 8.
Which page is it? 181 is something else.
241.
241.
It starts from that,
All right,
241.
241.
Kindly similar.
Ground number 8.
Whether the Honorable Division Bench of the Honorable High Court of Calcutta have failed to consider that in gazetted notification the schedule 2, 10 marks will be given for prior teacher. This point is newly added and with intention to accommodate those who are working as a contractual teacher in a private instance. So the benefit will not be given only to the untainted teachers. They have lost their jobs due to the fault of the school service as well as the state government. So by adding this clause, the state government are going to recruit the contractual teacher by allotting 10 marks extra. Next, my lord, ground 15. Page number 244.
Yes.
Whether the Honorable Division Bench of the Honorable High Court at Calcutta have failed to consider that this Rule 2025 is a perfect legitimate means for arbitrary whimsical action of authority. The authority cannot create any special class of people to give any extra benefit by way of experience marks. This rule has not a hint of reasonableness. The protection provided under Article 14 of the Constitution of Indian Constitution is also denied by this notification date 29th May 2000. That is the said rules of 2025 and the notification date 30th May 2030. The administrative further the authority arbitrarily whimsically can make the rule 2000 decide that the selections process will be held by following the 2020, thereby failing to provide equality before the law and equal protection of the law, and therefore notification and so said rule that the advertisement are unconstitutional, ultra-virus and so on. And Miller kindly take
Take one thing.
ground 7 also.
1 minute. These grounds are challenging which order of the.
That's the order of the division being presided by Justice Soman Sen.
All right.
Miller kindly come to Miller once. I'm sorry.
Page 194 is the order possibly?
Page, yes, page 194.
In terms of page 196.
No, main order ta kotha.
196.
Miller, main order is 196. Mr. Bhattacharya's argument ta tha.
196.
Miller, and you see, Mr. kindly come to 199. Paragraph 6.
Yes.
Mr. Bhattacharya has submitted that the finding, observation, and directions contained in the aforesaid orders are to be strictly followed. The notification of the WBCSC does dated 30th 2025 insofar as its attempts to fill up further vacancies would be in clear violation of the aforesaid directions and are not permissible. Mr. Bhattacharya further submission there has not been significant change in the rules of 2000 which would render the present applicable. It is submitted that the prior teaching experience for 10 years was not an eligibility criteria in the earlier. Moreover, the percentage so and so 48 with a clear malafide intention to make the present appellants disqualified and otherwise qualified candidates in terms of the orders mentioned above would now be not allowed to participate under the rules of 2000. The present notification and rules are intended to and tailored to exclude the candidates qualified to participate under the recruitment rules of 2016. Moreover, all the appellants of most of them have become overaged by the time limit and disqualified under state rules of all the appellants are victim of circumstance unless the state rules of 2005 is set aside and or the present appellant would lose valuable rights and have accrued in their favor under the recruitment process. Mr. Bhattacharya has strenuously argued that neither the order of the Honorable Division Bench nor to several orders of the Honorable Supreme Court has limited the participation to the candidates appointed in the state selection process of 2016 in the process. It is submitted that the word used are candidates in paragraph 45 and 5 of the judgment, which would include the candidates participating in the selection.
This is not relating to 10 marks.
No, not relating to 10 marks.
Not relating
Now,
to
Miller, kindly come to the judgment relevant portion, which is the finding. Kindly come to finding.
Internal page 22.
Internal page 22.
But my lady, may please see this was placed.
Huh?
This was placed before.
Miller, kindly see page paragraph 18 also.
State's reply, page 205. It pertains to prior teaching specifically.
It is submitted that when the expert committee has formulated the guidelines relating to recruitment of teachers, unless it is established such change of policy would be in clear violation of statute or constitutional provision, or arbitrary decision of the authorities are to be respected. It is submitted that the rules relating to prior teaching experience was one of the criteria in the notification dated 2026, and it has been reinstated in the recruitment rules of 2002 to ensure quality teachers in teaching standard. Whether the recruitment policy of 2016 is better than the recruitment 2025 is not a ground for declaring any of the rules as ultra-virus or to be interpreted as one. So, this is a submission. Now, kindly come to finding
19 and 20.
19. Now, in so far as the variation in marks criteria is concerned, Mr. Advocate General submitted that NCT is the expert body to fix up the criteria for teachers' eligibility. In our country, revision is requirement in make marks pursuant to NCT guide. But what I am submitting, this argument has been made. Then 20, now, my lord, that's the argument. Now, my lord, kindly come to submission. Come to relevant portion of paragraph. I'm just showing you relevant portion 24. Mr. Bandyopadhyay has justified the awarding of 10 marks for prior teaching experience on the ground that it is also extended to the teachers who have taught in schools under Kendriya Vidyalaya Sangathan, Navodaya Vidyalaya Samiti, State Council of Education Research and Training, West Bengal, and other government-sponsored schools. Marks for prior teaching have been provided with a view to appointing experienced teachers who will be able to teach students in the regard he has relied upon the decision of the Honorable Supreme Court, so and so. This is an intelligible differential between the unsuccessful candidates and in-service teachers, which is the writ petition have sought to well from the Honorable Court in this proceeding. Then other arguments, this is not relevant now for the timing. Now, Milord, kindly come to paragraph 34. The policy.
The awarding.
The awarding of 10 marks is an weightage to be given on the basis of experience, and if it is only expected that in a selection process of the nature and kind, all the candidates are required to undergo the rigorous of the selection process. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks be given to such candidates is not arbitrary. The object is to select and appoint experienced teacher, as rightly pointed out by the learned advocate general, Mr. Bandyopadhyay. Since appearing on behalf of the commission, the appellant are not coming within the purview of the categories in whose favor, benefit, and consents have been extended in paragraph 49 of the judgments of the Honorable. They are not the candidates selected in the 2016 recruitment process. In the meantime, they have not also applied for service in any educational institution. It shall be the duty and responsibility of the state to ensure quality education, and the eligibility criteria should be framed keeping in mind the interest of the students. If we accepted the submission of Vikas Ranjan Bhattacharya, learned senior, for the selection for the same subject, teacher, two different eligibility criteria has to be applied. The eligibility criteria in the selection process of 2016 is different from the recruitment process of 2025. The rules are more stringent and student-centric. The revision in the eligibility criteria is in accordance and consequence with the NCT guidelines. NCT is an expert body to fix the criteria. NCT is the statutory regulator for teacher education in exercise of powers, so and so. It makes regulations specifying wrongs, so and so. The commission has followed the state guidelines prepared and recommended by an expert body. There cannot be any compromise on the standard prescribed by the NCT. Education system will fail if we compromise on inequality, so and so. All recruitment rules must present eligibility criteria. This is then. Will not kindly come to next page. Page 219. This
paragraph they mention no rule challenge.
will maybe teacher for the this will yes line 4 kindly see the prior teaching experience is an important factor as experienced teacher may impart education for effectively and efficiently. The recruitment rules 2025 has not been challenged by any of the applicants. The delay in the fresh recruitment is due to the pending litigation, and when the opportunity for employment is open by always open for the authority to decide the eligibility and other criteria in the academic interest. And for the benefit of this, we accept the submission on behalf of the state respondent that there was no specific direction in the order of the Honorable Supreme Court by which the state is obliged only to fill up the declared vacancies on first SS1. So this is going on. Now come to paragraph 35. First, if the government felt, may I can, if the government felt that the experience gained by the candidate is relevant, the court cannot take a different view in judicial review. Similarly, percentage, any age limit for a given post and also deciding the extent to which any election can be given to the state age limit are essentially matters of policy. The criteria laid down by the recruitment process 2000 was intended to select the best of the candidates. The right to education guaranteed in terms of Article 21 clearly envisage quality education being imparted onto the children, which in turn would signify that the teacher must be meritorious and the best of the lot. Any process which applied equally to all the candidates and was designed to garner the best talent cannot be called in arbitrary. But although at the top of the judgment, although it has been said by Mr. Bhattacharya that no, we are not challenging the rule, but at the time of argument, he has dealt with all that. He made all these arguments. And kindly take the judgment in order of Justice Shogato Bhattacharya. That is very important, Miller.
Page 120.
Point is this, Miller, point has been taken. Thereafter, if any challenge has been made, argued in one court, then the higher court, some points should be, that is the case of abandonance. That is not the case that point has not. Kindly take, Miller, Justice Shogato Bhattacharya's judgment, page 128. Kindly come to para 5.
Page 131.
131, right. Right. Challenge has been, my lord, challenge has been thrown to West Bengal School Services selection for appointment of the post of assistant teachers for upper primary level of classes so and so rules, and recruitment notification dated 13 issued by the secretary so and so. Mr. Bhattacharya Anastina representing some of the petitions submitted in terms of judgment. Then para 5, you'll also see it is clear the challenge, whole challenge of the rules was there. Then kindly come to me, Lord, paragraph 10. Paragraph 10, yes. It is submitted. Yes. Another limb of submission made by Mr. Bhattacharya is against some of the provisions contained in the said rule of 2025. It is submitted that recruiting authority ought not to have altered the provisions relating to fixation of 50% marks instead of 45 marks, which is in earlier recruitment rules in graduation. But just pause for a moment here. Here, the Honorable Supreme Court has safeguarded that this 50%, that only 45% would be there. There was an interim order, which is in earlier to be alleged as eligible. According to petitioner, distribution of mark, that is 10 for prior teaching experience, 10 for interview, and 10 for lecture demonstration, or not to have been provided, which would given the recruitment authority and the interview board unbridled power to allot marks indiscriminately. Therefore, this point was taken before the learned single judge. Although Mr. Bhattacharya started before the division, we know we are not, but here he has made the submission. And before the division bench, while making his submission, he has made argument why the 10% marks are arbitrary. Therefore, his submission that no, I am not challenging, that is not reflected ultimately from the judgment. Now, against this, all this Supreme Court, SLP, etc., filed. Now, Obhijit Sadhu Khan, which I have shown to your lordship, he was not a party here in this matter. Obhijit Sadhu Khan preferred the SLP directly against this judgment, against both this judgment. There, I have pointed out to your lordships regarding the points regarding 10 selection. May I just, she is also here, she knows, she is here, I am also there. I just informed you, the Supreme Court has said that we will examine all the issues. Matter has been kept on 24th and 26th. 26th. Therefore, that kindly come to page 263 of the compilation. Kindly see status. But order was also passed. 26. Yes, notice a matter will come up on 26th. Date has been given.
The petition in our compilation. I'll show my lady.
Therefore, my lord, I have at the threshold I have said so that your lordships can now you decide whether your lordships will decide the matter or otherwise I am ready for making all my arguments here.
Sim number 9, the point that I have taken was that your lordship has gone through these all the orders, my lord, when these 10 marks are to be given and whether I have not challenged the rule and whether even if the rule is taken to be valid, whether 2016 candidates whose appointment has been declared null and void would be getting any marks. And for that, my lord, only one judgment of the Supreme Court in
No, no, এখন তো মুভিটা আসছে না।
like to place. My lord, lordship, no,
We'd
after the
like
third
Wait, we'll go one by one.
Yes, we'd like to
Because-
finish our submissions
Yes,
this
yes.
side and then go to that.
We shall go one
And
by
if
one.
your lordships wishes to hear the main matter, I have no objection. But I just tell you, lordships, my lord, I am making a submission.
But then more or less, whatever your submission is, you have made, that this is all right, it can be done. Division bench's order is in your support. This is
Uh,
more or less your
Stop.
argument.
And another one submission, my lord, that your lordships, the law is very settled. That is the binding precedent
But
of the division bench.
yes,
And very recently, Justice Bagchi has delivered a judgment regarding the binding precedent.
if you want to rely, you please.
No, and if no, if your this is the preliminary point. I have
Yes,
taken
yes,
this,
yes.
but if your lordship wishes to hear on merit of the matter, I have to make this argument. Kindly give this judgment. 2025. Bikram Nathta down. No, Justice Bagchita down. Okay, bhai. Is it in this? Yeah. Is it in the? Yes. কোথায় আমাদের কম্পাইলেশনটা মানে টেক আওয়ার কম্পাইলেশন
Yes, your compilation is here.
no judgments all judgments are not here. I'm sorry,
Again, judgment, such a big compilation and
there are so many judgments. Miller, just on the basic points, Miller. 2025 SCC online SC 970 paragraph 17. Kindly see
paragraph 17.
paragraph 17 of the 2025
Yes, SCC.
SCC online. Kindly let me read. Number of judgments are there, but I have just shown this. And latest day before yesterday, one judgment has been delivered by Justice
All right.
Bikramath. Recently, it is argued that there are cases or counter cases and proceeding against parents-in-law have been quashed by the coordinator. Nothing the parents-in-law are septuagenarian, and there is no whisper in the FIR that they participated in the assault proceeding against them was quashed. Uncontroverted allegation the FIR charge sheet. He stated on the same footing putting when the other in-laws, brother-in-law, sister-in-law against whom the proceeding was not quashed in criminal petition, though the order refusing to quash the proceeding against some of them in-laws was purposely impugned order. It was incumbent of the judge, while quashing the proceeding against the respondent husband, to refer to the earlier decision of the coordinate bench and distinguish the reason therein to arrive at a different conclusion. Failure to do so infracts judicial propriety and discipline. Consistency in judicial outcomes is the hallmark of a responsible judiciary. An inconsistent decision coming out from different benches shake public trust and reduce litigation to a punter's game. It gives rise to various insidious sharp practice like forum shopping, spoiling the clear stream of justice. Impugn order suffers from the vice of judicial caprice and arbitrariness and is liable to be set aside and also on this score. And very written, my lord, there is the judgment of 2025 SCC on line Supreme Court 2366, paragraph 1 to 14, 1 to 4, the Kobe judgment delivery, you know. This is 7th November judgment. Madam. Lord, the
Paragraphs 1 to 4.
1 to 4.
Yes.
The judiciary draws its strength from discipline and not domination. The Constitution of India creates courts of record that are independent in their spheres and yet binds them together through a coherent hierarchy. The High Court in India possesses a wide jurisdiction, but the Supreme Court of India remains the final interpreter of law. Article 141 of the Constitution of India declares a law laid down by this court binds every court in the country. Further, Article 144 of the obliges all authorities, civil and judicial, to act in aid of the court. These are not ceremonial recitals. They are the structural guarantees that convert dispersed adjudication into a single system that speaks with one voice and commands public confidence. Appellate jurisdiction exists to correct errors and to settle the law so that like cases receive like outcome. When a superior court reverses, modifies, or renders The court below must give full and faithful effect to that disposition. The authority to decide an appeal carries the authority to require compliance for without obedience. The hierarchy would become an empty form. Resistance or evasion does not merely deserve a party. Before the court, it erodes predictability, multiplies litigation, and weaker faith in the rules of law. The maximum interest replicate unsick finds litium, which literally means that it is the public interest that litigation should come to an end, reminds us that the society has an interest in achieving finality, and finality from the apex court in the guise that holds the nationwide system of justice. Judicial discipline is the ethic that turns hierarchy into harmony. It requires courtesy, restraint, and obedience to binding precedent, even where a judge is personally unpersuaded. The lawful course is to apply the precedent and, if needed, record reasons for inviting a larger bench to reconsider it. The unlawful and unjust course is to distinguish in name of while disregarding in substance or to recast issues in order to sidestep a rule that binds. Stare decisions are not movers, which means to stand by decision and not to disturb the settled matters, is not a slogan but a safeguard of equality before the law. Judges do not sit to settle scores. The gavel is an instrument of reason and not a weapon of reprisal. A vindictive stance is incompatible with the oath to uphold the constitution and the law. Judges across our country must remember that collegiality is the companion virtue of the independence, and that a reversal on appeal is not a personal affront but the ordinary operation of a constitutional hierarchy that corrects error and settles law. Respect for the senior jurisdiction is not subservience. It is an acknowledgement that all courts pursue common enterprises is to do justice according to law. An appellate court reviews and, where necessary, sets rights the decision of the lower court with restrained and measured language, and the courts below reciprocate through prompt, reasoned, and transparent compliance. Court speaks through reasons and reasons that align with the binding authority, preserve both the legality and legitimacy of the judiciary. Article 144 of the Constitution makes obedience a custodial duty and not a matter of personal preference. A judgment that attempts to resist binding authority, undermine the unity of law, burden litigation which avoidable expense and delay, and invites the perception that outcomes depend on the identity of the judges. In a constitutional judiciary, it is the law as declared that brings the conversation to a close. We restate the simple duty of the courts, apply precedent as it stands, and give effect to the appellant's direction as they are framed. In that discipline lies the confidence of litigants and the credibility of the courts. This is a preliminary point which I have taken, that otherwise, if you let's say feel to go into decide the matter, then I will address on merit.
Take it on merits. What further? You've made 11.
No, merit I have to make so many submissions.
What submission?
Hmm.
Because all your submission is possibly recorded in the judgment of the Honorable Division Bench. It's a big detailed judgment with the precedents that you've relied upon.
Yes, that's correct. That's correct. But that's a
Advance arguments on maintainability before my lady. I'd like to supplement.
That's
Mr.
Milord,
Banerjee,
yes.
you mentioned
No, Milord,
on maintainability.
Milord, I have been told by my juniors that the observation, reasonable classification, obiter dicta, etc. That if your lordship wishes similar, I can address that also.
No, in that case, I have to hear the petitioners first.
Well, that's naturally. Otherwise, Milord, judgment which I have been telling, Milord, my simple submission is this.
The matter is pending before the Honorable
Supreme Court.
Stay their hands for the time being.
Let us see.
Exactly the same line of Mr. Bandopadhyay, because I will not be repeating even with the same sentence. I am completely adopting it. Only I shall be saying two things. Thing number one, there is a 2025 judgment of the Honorable Supreme Court, which Snehal, 2025 SCC online SC 2325, paragraph 10. Justice Gava's judgment. Chief Justice. This is exactly what Mr. Bandopadhyay has submitted, and I am also adopting it. So,
Just the language.
that is
Not in
paragraph 10.
Yes.
we are deeply perturbed by the approach of Sage Sri Rahul as well as the High Court of Uttarakhand when the Sage Sri Rahul was continuously, kindly mark this word, because this whole thing started for a long time, continuously following the proceedings before this, that is Supreme Court, and was aware about the oral observations and the orders. If I can just have a little pause. Last night, I myself saw the entire video of what exactly was submissions on the part of the petitioners for the SLP, and I was completely convinced. All these were there. The Honorable Supreme Court had something specific in mind,
Madam.
which cannot be given to everyone. Like, what is the meaning of tainted? What is the meaning of untainted? What in the context of a list? All aspects. Why the freshers? They were not given relaxations. All were argument made and negated. Now, if I continue, and the orders passed by this court, nothing prevented him from intervening in these proceedings if he was of the view that any of the orders passed by this court or any of the observations made by this court prejudiced him. However, in the teeth of the sanction which was granted during the pendency of the proceedings before this court, approaching the High Court to challenge an order virtually amounts to this interference in the present proceedings. The High Court, no doubt, is a constitutional court and not inferior to this court. However, in the judicial matters, when this court is seized of the matter, this is the words, seized of the matter, it is expected of the High Court to keep the hands away. Well, that's the reason I said it's not that Lordship doesn't have power. There is something, we use the word propriety. When the Honorable Supreme Court is seized of the matter, it despite of the fact that Lordships can, I'm not saying taking an extreme view, cannot at all, can, if Lordship goes into that micro analysis of it, most likely, if there are two options, both options being available, Lordships might choose the options of not interfering because of the simple reason that the Honorable Supreme Court is in seized of the matter. So this is clearly on this. Now, just one more point, and I would not say anything. My lord, kindly, my lord, visualize a very fundamental thing. When a legislation or a rule is challenged, two things are different. One, what is challenged, and what are the bases of the challenge. What is challenged is a fixed rule. Basis can be X, Y, Z, etc. In the prayer in the writ petition, there was a specific challenge so far as this rule is concerned. It is possible that, my lord, there is always an innovative argument. Kindly visualize that once the rule which has in the prayer was challenged and it was not granted, rule was not declared to be ultra vires, and the matter ultimately went before the Honorable Division Bench and the Honorable Supreme Court, just because of one sentence, well, in fact, factually, that's an incorrect statement. That rule was not challenged before the division. That's not factually correct, because I have seen the prayer. In the prayer, specifically, rule was challenged. And that is also corroborated with Mr. Bandopadhyay has referred that the Honorable Justice Shogato Bhattacharya also recorded regarding specific point of prior teaching experience. So all I say, it is possible that there can be a new XYZ.
Anyway, your submission is also to stay the hands.
Yes.
My lady, may I just address you? I've just capsulated all of this in a short note, 5 pages. My lady will have everything. And this is the compilation that goes with it. Please pass this on. This is the compilation that goes with it.
You are appearing for one of
I
the
appear
interveners.
in 4 cans. We prepared a list.
Interveners.
Yeah,
All right.
interveners. Can 4, can 1, and then in writ petition 24899, can 4 and can 1. So
All
4
right.
sets of interveners. We are obviously here also on that the merits have been argued, but simply on maintainability. I'll just take you to the first page. Now, my friend Mr. Banerjee very eloquently argued this principle of stare decisis, which my lady is also bound by. And my lady, may I just start by saying this is my first physical appearance in my lady's court. It's an honor to be here.
Yes.
Very
Thank
happy
you.
to be here. Now, my lady, may please go to page 2 of my submissions. Just page 2. This is para 9. This is the petition where the Supreme Court has issued notice on. This is the petition where the Supreme Court, this is Avijat Sadhukan versus State of Bengal. Notice has been issued by the Supreme Court on 25/8/2025. Relevant grounds of challenge are at questions of law para, and we can look at those pages. And if you just see the pages of the compilation, we want to make this very simple and convenient, my lady. My lady may eventually agree or disagree, but we want to make it easy. So please see page 415 of the compilation that I've just submitted, page 415. This is the petition that was filed, the SLP that was filed in the Supreme Court, on which Justice Sanjay Kumar and Arvind Kumar issue notice. And this is the bench of the Supreme Court which has been seized of these matters pertaining to recruitment of assistant teachers. Now please see page 415. My lady has the compilation. Paragraph 8.
Are you all aware of this?
Paragraph 8.
I don't want to waste the time of court.
Yes.
Can I just take you to this? Yeah, let me just finish.
Then get exhausted. I will
No,
give a speech.
you tell me one thing. If the issue is pending there and you can raise all issues over there, let the court stay its hand for the
Yes,
time being.
yes, my lady.
There-
Yes,
No such issue of constitutional violence is pending. Let them
this
go
is
and
wrong.
take up.
May I just finish?
What
Let me just.
SLP means, Milord, I don't have to teach anybody what
Yes,
SLP
yes.
means.
Yes, it's all
But the
right.
SLP, Milord, really arose from the fundamental order passed by the High Court, where High Court says that the violence of
Whether 2016 rule will apply or the 2025 rule will apply.
that is
This is the
different.
this is the
That was,
challenge.
in my
The
petition,
virus of 10 marks. That is what is pending before the Supreme Court, amongst 12 other questions of law.
Yes.
no, Milord, here we have challenged the constitutionality of 2025 rule,
Yes.
That was challenged.
which was never before the court. The division bench was very categorical, saying the rules are not challenged. The division bench interpreted on the strength of the rules being valid. Now I am more on fundamental. I know they are scared of going
on
into the
the
issue.
strength of the rule being valid means the 2025 rules is valid.
Yes, this is the issue now. I am urging, I am an independent petitioner, that council might be saying, but council.
No,
Milord,
no,
is
I
not-
understand. But if the issue is decided, then there is no point in
Yes,
deciding
it is pending.
it all
It is-
over again. It cannot be done.
Issue, Milord, is not pending. The Supreme Court, with deepest of respect of my little experience, will not go beyond the fundamental order passed by the court. Therefore, here, raising the issue is really Milord, simply trying to avoid the court, nothing else.
My lords, my lady may please see page 414. These are the questions of law that are pending before the Supreme Court. Please see that the Calcutta High Court has failed to consider the entire recruitment rule of 2016, and therefore the second state level selection test 2025 is completely changed. This is page 415. Please see the bottom of page 415. Question 8. Whether the Honorable Division Bench of the Honorable High Court
Was
of
read
Calcutta
out just now, Mr.
yes,
Bhatt,
has
read
failed
out
to.
this.
This is the petition that is pending at the Supreme Court, which the Supreme Court has issued notice on. So when the apex court is seized of the matter, including any and all questions that are being raised by my friends through a backdoor entry in violation of stare decisis, judicial discipline, and hierarchy of courts,
What is
I don't
this?
know what this is. Please stop all this. Please stop all this.
1 minute.
Please.
Who are not the advocates will please leave the courtroom because the entire proceeding is live streamed and anybody can see. Please leave the courtroom.
Now, may I keep reading, my lady?
Please leave the courtroom. This is not this way how the Calcutta High Court functions. Apart from advocates, please leave the courtroom. What is happening? Right, will please leave. Whoever's clients are there, please leave.
May I keep reading, my lady? Whether the Honorable Division Bench of the Honorable High Court, bottom of page 415,
Yes, yes.
has failed to consider that in Gazetted Notification Schedule 2, 10 marks will be given
this is
for
what
prior.
Mr. Bandyopadhyay
Yes, now
read.
may please see,
My lord, we'll
please see
try to go
15,
through this.
418. Can I finish, Mr. Bhattacharjee? Is this the way we argue? Let me finish my arguments, then you please. Now
Wait,
please
wait,
see
wait, wait.
418.
What you want to show?
But this is a calibrated attempt to disturb the functioning of this court. But I'm not, this is the Facebook posting by one of the aspirants who want to get 10 marks, not being qualified for this purpose. They are
Terrible.
posted. কাল সকালে কোর্ট চত্বরে সকাল সকাল যেন ভিড় করে থাকে। I am not mentioning the name of the judge. ঢোকার সময় যেন দেখতে পায় ডাল মে কালা হয়।
No,
আজকে
no, this
জিজ্ঞাসা
is-
করতে
this
বলবে
is
আমাদের
terrible.
কেস আছে সেই জন্য এসেছি চাকরিহারা শিক্ষক শিক্ষিকা।
Please leave. The doors are quite wide.
This
Y'all
is
can
the
leave out.
These are the persons.
How, Mr. Bhattacharya, if you place this, we can place so many of your junior statements.
Yeah, this is not the way it's done. This is not the way it's done.
Copy, whatever they will be placing. But this copy has not been done despite your lordship's direction. But they had agreed that they will.
Affidavits of service are
Before they
complete.
place any document.
Soon as if they cannot go out, then the court has to stop.
Advocate, nobody
Yes.
should be allowed to. These matters,
Since the proceedings are live streamed, everybody can see it.
Absolutely.
What is the
Very
use
bad.
of long
Absolutely.
court?
extremely bad.
It's absolutely no use.
Placing.
And if they think that they're going to put pressure on the court,
This is the
I'm
petition.
sure the bar is there to save
No,
the
no, no,
bench.
no, Bharat, no, please, of
This-
course,
no.
no.
This,
Bharat, what I am
Sure.
submitting from the next day, whenever these types of matter, no.
yes,
Nobody,
outsiders.
no litigants. My lady, may I keep reading? Page 418, ground
Yes.
15. Ground 15 of the petition filed in the Supreme Court.
So the-
Whether the Honorable Division Bench of the Honorable High Court at Calcutta have failed to consider that this Rule 2025 is a perfect legitimate means for arbitrary whimsical action of the authorities. The authority cannot create any special class of people to give extra benefits by way of experience marks. This rule has not a hint of reasonableness. This is the ground. The protection provided under 14 of the Indian Constitution is also denied by this notification dated
Yes, yes, these
29.
also have been read.
This is exactly what is challenged before my lady. Now please see, my lady. Please
1 minute.
note-
You are reading from Abhijit Sadhuka, isn't it?
Yes, my lady.
Are the petitioners aware Abhijit Sadhuka's petition? Please take down note.
They are aware about Orunima Pal.
Orunima Pal.
Orunima Pal as well, my lord, is there.
Abhijit
No, no,
Sadhuka.
my lord, we have, my lord, Abhijit Sadhukal's copy was served on last Saturday
No,
to Mr. Sami.
they do not know. They are not party.
May not be.
We've given a copy of everything. All the arguments, judgments, rules, everything.
Mr. Samir, Mr. Dasgupta,
But
But
Abhijit
y'all-
Sadhu Khan's SLP, my lord,
this is what is read. Not received,
Mr.
get a copy.
Mr. Bandopadaya's copy and
They are all members of Orunima Pal. If we are aware of Orunima
Yes.
Pal, my lord, I'll show that every point was taken.
All right.
Yes. Now may I just take you to page 431, which is the
Right
Supreme
now, it is Abhijit Sadhuka's SLP grounds
Yes.
that are being placed.
page 431, Supreme Court issuing notice on this petition, the grounds
Right,
which I read.
All right, all right.
Please see, it's a detailed order. Justice Sanjay Kumar issues notice. It's a detailed order. Now please see. Can I just take you back to my note, page 3,
issue different.
again on maintainability.
আমি যার ভিতরে সে বলছে
1 minute, 432.
431, my lady. It starts
Yes. The next
25A.
page, yes, next
Yes.
page. I see
Issue.
notice have been issued.
and tagged with SLP diary number
Right.
titled Bibek Paria.
And the court directed that in the meanwhile, all selected and appointed untainted candidates,
Yes.
selected and appointed,
Yes.
who were permitted to continue shall be allowed to participate in the fresh selection
Yes.
without insisting upon complying with 50%.
Yes, my lady. because the Supreme Court had
So this is
on this 50% criterion
Had
had
interfered.
protected it because
Right.
of the nature of this recruitment process. And you'll see at the bottom of that same para, classes 9 to 10, classes 11 to 12, rules 2025. It is exactly what is pending before my lady.
All right.
Exactly. Now, please see, may I just take you to page 3 of my submission notes on maintainability again, page 3. We have now, Mr. Banerjee has now gone through stare decisis. We have now shown to my lady that exactly the same questions, the same issues are pending before the Supreme Court where notice has been issued. Now, the third point, the law on this, the law, why this is not maintainable in law as well. Top of page 3. Qualifications for appointment. My lady has this, top
Yes,
of page
yes,
3.
yes.
Qualifications for appointment to a post are within the exclusive discretion of the employer. So these 2025 rules, my lady, now the Supreme Court has settled the law in Maharashtra public servants. Now prior experience, please see middle of this page. Prior experience marks in teaching, middle of the page of same page 3, were upheld by the Supreme Court in Allahabad University versus Gitanjali Tiwari. This is what I told my lady virtually when I was appearing, paragraph 16. The practice of according marks for prior experience in a recruitment process is not unique to this recruitment process.
All right. Yes.
UGC regulations, my lady, this is all India regulations on minimum qualifications, has exactly the same rule.
All right.
You will find exactly this rule in many states vis-a-vis recruitment of teaching, and they are all sustained on the basis of these two cases of the Supreme Court. That the employer, in this case the state, gets to decide within its executive and legislative discretion that we require this prior expertise. A class 9 student would benefit greatly by having a teacher who's got 2-3 years experience as opposed to having a fresher. Now please see page 4. I prepared this note just so that I won't take much time of my ladies. Please see page 4.
Only one thing. Case Lordship feels that Lordship is not going to interfere. It may not be proper to say anything on merit. That I feel.
No, nothing on merit.
No, nothing on merits.
Right
Nothing on
now,
merits.
I'm thinking of whether to entertain.
Yes,
not to
maintainability.
entertain.
Maintainability.
Situations we won't be able to.
No,
discuss.
no.
Yes. No, this is on.
Not on merits.
Either it
Not
goes-
on
My
merits.
friend may let me argue. I didn't interrupt you.
merits.
So please see paragraph 14, page 3. Just on maintainability. Paragraph 14, page 3 of my submission note.
Yes.
Please see what the Supreme Court says on qualifications. What is before my lady is the ability of an employer, the state, to prescribe qualifications. Can a court traverse that? Please see what the Supreme Court says. Maharashtra Public
Not
Service.
on merits, please. Not on
No,
merits.
my lady, this is not on merits. This is on the principle of law.
Un-
Employer may prescribe
Right
additional
now-
or describe.
Right now, what is going through the mind of the court is whether to hear y'all at this stage or should I wait till the 24th or the 26th?
Please wait, my lady, while the Supreme Court is seized
What
of this.
is, going
Yes.
through the mind of the
Yes, and this is a
Right.
bench of the Supreme Court because I've argued it from day one before Justice Sanjeev Khanna.
No, no.
This is a bench of the Supreme Court that has been seized of this matter from when Chief Justice Sanjeev Khanna first set aside the recruitment. Now Justice Kumar is hearing all these petitions from Calcutta on recruitment
All right.
specifically.
Mr. Bhattacharya.
May I just hand over the note that your
Again, note.
that small note your lordship wants on the other day?
One has come. This is the second one.
I have not.
Please don't.
See my side.
Yes, the slimmest.
No, I have not given note. I have given the documents and the judgment.
This one
I
is
have
also
given
the
a
document.
note, my
Not
lady.
note.
See the number of candidates involved. For this, the documents are so
I have set out the prayers
is a
that have
copy.
been made.
two
Because the
copies.
copy.
Two
You
copies.
don't allow.
Two copies have come.
I'll
My lady, we'll take
Give
one
the
copy.
copy
my
first, then I will
lady. We'll
come.
share my lady's copies.
You can't able to.
You are also for one of the interveners.
Yes, in can number 5 and item number.
Whatever.
You're supporting us. Okay, then I thought it that you are Mr.
Couldn't
Support.
understand whether supporting or opposing.
Please support.
He already missed
My lord, those supporting are genuinely more jovial, my lady. We are optimistic. Those opposing are not so.
Have set out the prayers made below in each and every new petition which has been disposed of. And you also will find in only Mapas, there was a specific prayer challenging the rules. My lord.
No, no.
In a separate petition, my lord, a petitioner can challenge even the order passed in a similar petition by the other court. Kindly takes up, my lord, what is the foundation? Order of Honorable Justice Shomen Sen in Math 1017. All SLPs arose from this. Well, let us go to the basics.
Will it be very difficult, Mr. Bhattacharya, if when the matter is taken up by the court on the 24th or the 26th, the Supreme Court, you'll get an order, one-line order, that this can be urged before this bench? The court will be open to hear it.
Lord, I
Why transgress?
am not before the Supreme Court. I am a petitioner.
Independent.
No, not
Because
this
it is the
party.
court,
That is different. That is different.
Because
I
as a
understand.
Counsel,
No, as a counsel, it's all right.
I have argued on the same
Yes,
day,
yes,
different
yes.
positions. Well,
Right.
let
It's
them
not that.
confuse it.
It is not that.
Petitioner before
But
your-
there are many who are parties over there. If one line order can be obtained from the Supreme Court that this individual challenge to the rule can be entertained by the High Court, the court is open to it.
No, my lord,
This will
Yeah,
settle issues.
may I answer? Lord, you kindly excuse my impertinence.
No, it's all right.
But the question is, the Supreme Court will mock at me that having not gone through the order appealed from, what is the order? I just placed the order. Kindly takes up, my lord, the division bench.
The order has been placed.
No, they have not.
You
placed it in the
have-
issue. Lord, I am sure the order has not been placed in the context. Lord, kindly come to me, Lord. The kindly takes up the judgment of the division bench. The present appeal, paragraph 2. Lord, we have seen in the country, my lord, how, my lord, the tainted peoples always wants to take advantage of, my lord, the situation. And the law is well settled, but they cannot be allowed to participate and get the marks. The present appeal, I am talking everything on authority. I am not talking on my own wit.
Compilation দিল পেজ নাম্বার 371
The
বলে।
present appeal, paragraph
Joshua
2.
Pai. Page number 371 of Abhijit Sadhaka. 371. Page number 3.
Division bench judgment.
Orunima Pal. 371. Page number 371.
This appeal, just honorable division is considering the present appeal is directed against a portion of the impugned order whereby the contention of the appellant that the recruitment process initiated in 2025 on the basis of the said rules of 2025 could not be made applicable to the present appellants as they are to be considered under the recruitment rules of 2016 was rejected by these orders.
What I could understand from the order of the Honorable Division Bench is that the broad question was considered by the court whether 2016 rules will follow or the 2025 rules. Nothing individual. This is what
This was, and
I
that is
could
what-
understand.
And you have correctly
Right.
understood that is the scope of the division bench
Right.
judgment.
Now, at the time of deciding this, the court has gone into the finer points, whether 50% is proper, whether 10 marks is proper, and whether the authority can fix up the eligibility criteria and all these things, and the court has passed order. But I have seen the issue before the court was something different. This is what
Absolutely.
this is what came to me.
And court would have
Right.
really said that these issues are left with the executives. Court cannot interfere.
Right.
Now, my
Now-
point is here that these rules will not violate the constitutional provision. If I can satisfy, otherwise, my lord, I am out.
Right. So I will prefer waiting till the 24th or the 26th rather. Let us see what happens because the issue is pending. Whatever order will be passed by this court will always abide by. The steps taken by the authority will abide. That is the interim order in one of the matters.
My lord would be pleased to then record that while the matter has been considered for constitutional validity, the point is taken that these constitutional validity is being considered by the
Yes,
Supreme
yes, I'll record that in the
Court. And
order.
on that ground.
Yes, yes. On that ground only.
This is one point. But another petitioners I am representing, where we not taking the rules 2025 as it is, even then at what stage the
10 marks can be awarded. I'll come to that later on. Let me record it.
Item number 14.
That is separate. That is separate. No, 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 I'm not saying. This is
আরে ওটা
whatever.
no.
That was our.
Whatever. See, a client, when a litigant comes, when a litigant comes before the court,
প্যারা 34
the litigant prays for the moon, but the court doesn't consider that.
No, no,
The
court
court
says the
fix-
recruitment rules of 2020
I
has
see,
not
I
been
have-
challenged.
Right, so I'll please come.
My lord,
Please come.
my lord, serial number 14, my lord. This is issued completely different because my lord, 9, 10, my lord, the untainted teacher is eligible to get marks for the 11, 12.
3. This is item 3.
Yes.
This is item 3. Just wait.
স্যার ইন্টারভিউ লিস্ট পাবলিশ হয়ে গেল
বলছি দাদা,
সাবজেক্ট আউটকাম সাবজেক্ট ম্যাটার অফ আউটকাম অফ দিস রিপিটিশন সাবজেক্ট ম্যাটার অফ আউটকাম 3 4 আমাদের আইটেম নাম্বার গুলো বলো
সেদিন আমি থাকবো চাকরি দরকার নেই।
স্যার 5,000 লোককে চাকরি দিয়েছি
The issue as to whether 10 marks can be allocated for prior teaching experience in the
In open selection, direct recruitment.
2025 rules. লিখে নিন তো, West Bengal School Service Commission selection for appointment to the post of assistant teachers for upper primary level of classes except work education and physical education. Classes 9 and 10 and classes 11 and 12 rules 2025 are impugned herein. Stop paragraph. Learned counsels representing the commission, the interveners, and the state respondents submits that the said issue is pending consideration before the Honorable Supreme Court and the matters are due to be taken up for consideration by the Honorable Court on the 24th and 26th of November 2025. Stop. Next. Though the aforesaid submission of the respondents has been opposed by the learned counsel representing the writ petitioner, but as several grounds of the special leave petition have been placed before this court, this court is not inclined to adjudicate the issue at this stage. Stop. Hearing of the writ petition stands adjourned till 28th November 2025. Stop. Parties are directed to produce the updated orders of the Supreme Court on the adjourned date. আরেকটা জিনিস, compilation filed by the West Bengal Central State Service Commission, School Service Commission, the interveners in court today be written with the records.
One thing that has not gone down, that the court was invited to decide the constitutional violations of the 25 rules. That is not pending with the Supreme Court.
Achha.
That he would also record this rule was challenged before the.
That record from the order.
Is there in the order. Why record all these things? যেখানে বললাম না, it is not challenged. যেখানে বললাম opposes the submission, ওখানে লিখবেন the constitutional validity of the 2025 rules have not been challenged.
Yes. Now the parties may get a clarification so that this will.
I am not mentioning. If you can get it done, fine.
Very well.
This is, you have said.
No.
This is item 3.
In the SLP, how can a varies be challenged?
This is item number 3.
My lord, item number
Item
3, 4, 11, 12 and 13 are similar.
3,
4,
4,
11, 12 and 13.
11, 12 and 13. same order will go down.
হ্যাঁ না এবার স্যার আর একটা কথা বলে দিই
Let the petitioners come. No, let the petitioners come. Item 5.
ফাইভটা কি?
on
Is it the same thing? It is something different. Totally different. All right, please wait. Please wait. Item number 6 is also different.
সরকারি স্কুলের টিচারকে প্রাইভেট স্কুলের টিচার চ্যালেঞ্জ করেছে
Wait. I'll take it up.
রেখে দেবে তাহলে ইন্টারভিউ ইয়ে হবে ইন্টারভিউ
Item 7.
My lord, may I indicate one thing, my lord? Because of that matter, I challenge the 10 marks and if is given to the government school teacher, the same, my lord, benefit ought to given to the others teacher
Which
also.
one?
That is not in the list, my lord, already filed, my lord. I supply the number, my lord.
yes.
Otherwise, my lord, the list will publish, my lord, within 1 week, my lord. Matter will become infectious, my lord. It will be kind enough, my lord. Kept any day, my lord, my junior will supply the list.
Item 7.
Item 7 and 8, the issue is whether central government school will get the 10 marks, my lord, 14th your lordship has been.
14th.
7 and 8.
But then objection, yes. The commission doesn't have any objection. Yes, against sanction post.
Sir, that I will satisfy your lordship.
But the 14th, 7 and 8 on the 14th. 7 and 8 on the 14th. Item 9.
My lord, 9 in.
আমরা এগুলো বের করে দিই। Supreme Court of-
I'll put an additional point in 10. 9, Mr. Dasgupta was arguing in the last.
All right.
আচ্ছা।
দেখি 9টা একটু দেখি।
এগুলো আমাদের, এগুলো সব আমাদের। এগুলো সব আমাদের। ঠিক আছে, এগুলো বের করে নিন।
There are many oppositions.
এটা তোমার নাই? হ্যাঁ।
এখানে দুটো পয়েন্ট কখন দিতে পারবে পুনর্জাগরণ পাবে না টেকিং দ্য রুল টু বি ভ্যালিড
That is also there, my lord. It's not appearing in the list. I'll number.
It is there in a pool. Now it has become a pool.
Now it is there in the board. And on the point of contractual, my lord.
Commissioner হয়তো commissioner
Yes, Shishir Dash, item 9.
Wait with your lordship.
না স্যার
Retreat. Puro, entire file.
হচ্ছে না
This is regarding the stage as to when the marks is to be added.
The interpretation of rules.
But then will we go into this? Let the court decide, Supreme Court, as to whether the 10 marks will be allotted or not. If it is not allotted or allotted, then
But no, the problem is, Milord, in the meantime, what they are trying to do, they will, Milord, get these, Milord, the favored students again selected, and publish the result, making and shouting that this has become infructuous. Therefore, there are two prongs of attacks. One is constitutionality, it remains. Milord, even after 10 years, it can be declared otherwise.
yes.
But here, Milord, assuming that the rules are valid, what should be the interpretation?
What should be the stage? Yes.
Kindly come to Milord.
It's not about
No, successful or not is different.
Milord, I am a Milord fresh candidate.
14,000 on this 100. 22,000 is open to market. Why Mr. Bhattacharya is thinking?
Why should I
No,
give
if
40,000?
22,000 is there,
Yes.
then why this 10 marks?
No, 10 marks is
When will you add?
what experience.
When will you add?
I am ready.
When will you add?
I will get it before interview.
Before the interview.
I will get it
Before the interview.
That cannot be done.
It has to be done prior to the
First of
declaration
all,
of the
Milord-
final merit list.
Milord, and second question would come whether, Milord, these after the Supreme Court judgment, Milord, whether they can be treated as, Milord, qualified teacher,
Qualified teacher.
because they have the benefit of trying to get the benefit of experience,
Yes.
and after the appointments having declared void, whether they can be said to be qualified teachers.
That means the 10 marks issue comes in, right?
10, 10
10
marks.
marks.
But the one is below 10 marks cannot at all be allotted, irrespective of who is there. Here, my lord, if I take the rules does not permit the tainted in the sense as the Supreme Court said, whose appointments are declared void by the court. I have made similar judgment in other cases also. Therefore, we are sticking to the interpretation of the rules. And I'm inviting my lord to deal with this.
No, what will be the, what answer do you want? That the 10 marks can be given to the past, for the past teaching experience, or the stage?
So, two issues are here. First of all, if at all 10 marks can
Is
be given, then
at what stage?
At what stage?
Right.
Second, my lord, the 10 marks can be given, my lord, to the teachers having the experience, past experience. What
Whether the candidates who participated in the earlier recruitment process
could
will
be,
get
could
the
be taken as a
eligible.
past experience. That's the point. But kindly come to the rules straight away. My lord, the
This is what his submission is.
no, I don't say I could be allotted, but not to the teachers who have no experience in eye of law. Yes. Well, let me, whole difficulty is that I am gagged. Let me speak out.
Let this hearing be done one by one.
Let us start. But, no. Let me please it. I will be happy to be wrong.
Wait.
I don't claim that I am always right, but let me speak out. Kindly come to the rules.